ਹਾਂਜੀ ਸਤਿ ਸ੍ਰੀ ਅਕਾਲ ਕੀ ਹਾਲ ਨੇ ਸਾਰਿਆਂ ਦੇ so today we will be discussing about the topic sedition. What do you mean by sedition? It's a very important topic for all the law students. So section 124A of IPC defines that whoever by words, spoken words, or by some writing, or by some signs, or by some visible representations, or otherwise brings or attempts to bring hatred or contempt. So what do you mean by hatred? Hatred is a simple, very strong feeling of dislike, dislike towards any person or something, or even in this context, as far as sedition is concerned, hatred towards the government established by law in India. And contempt means feeling that something or somebody, here even the state, is without value, or the government of India, established government of India, deserves no respect at all. So whoever does this by bringing or attempting to bring hatred or contempt, or even excites the people, or attempts to excite them in the way that there is some disaffection, so exciting some disaffection towards the government of India, that is government established by law in India. So obviously every government is established by law in India through elections after every 5 years. So if the person is doing this, he will be punished with imprisonment for life. This is the maximum punishment, or to a fine which may be added, any fine, or he may be imprisoned with the maximum of 3 years, to which fine may be added. So either life imprisonment and fine, or to maximum of 3 years and fine, or he can be punished with just a sort of fine also without any punishment. So this was the main definition of sedition under section 124A of IPC. There are three explanations also. It says that disaffection, here the word disaffection includes disloyalty and all feelings of enmity. Uh, Disaffection means no longer satisfied with your present situation, no longer satisfied with the organization, here even the government of India, therefore not to be loyal to it. And feelings of enmity against the government of India, feeling of hatred towards the Indian government. And here explanation 2 says that comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offense under this section. So just by you are just uh, mm, I mean to say, you are there is strong disapproval against the measures of the government of India. You strongly disapprove the measures taken by the government of India. It includes safety measures, security measures, official action that is done to achieve a particular aim. So there is a strong disapproval against the measures or the policies of the government of India. It doesn't mean that uh, uh, there is sedition. It doesn't come under sedition. And the third explanation is comments expressing disapprobation, strong disapproval, same thing, of the administrative or other action of the government. So if there is any administrative action of the government, or the government officials, or the government machinery, and but there is no excitement of hatred or contempt or disaffection uh, against the government of India established by law in India. It is only against, strong disapproval is only against the administrative and other action of the government. It doesn't mean that there is an element of sedition. So these are the three explanations here. But the thing is that this topic is a rather a real controversial topic. Recently, Supreme Court has also snubbed the government that as far as sedition is concerned, don't you think that this law is too old now and it should be struck off from the statute books, that is IPC. The government had its reply. We will be doing it at the end of the lecture. But the thing is that there are very important points which I will be dealing with, which is very important for all the law students. Here, the government word which is used in this definition, it includes both the central and the state government, various government departments like police, army, air force, navy, various government agencies. So all these are within the definition, within the term of government. And government measures includes various policy measures implemented by the government, various bills initiated by the government in the Lok Sabha or Rajya Sabha, various administrative orders, bylaws, rules, notifications, circulars issued by the government or its administrative officers or even government agencies. Then the third very important point to be noted is if there is a meeting of the people or even if there is a meeting of opposition parties, and the purpose of that meeting is to analyze the pros and cons of various policy measures of the government, or even having a political discussion, general political discussion, as we always see general political discussion in the TV debates also. So that's not illegal, and until and unless that debate, that meeting is peaceful and does not incite violence. If that meeting incite violence in the minds of the people who watch that meeting, who are in that meeting, then obviously you can be held liable under sedition. So there is a element of violence. There is a fear that you are exciting the people of India. You are exciting them against the government of India, to do violence against the government of India. So there should not be any such type of thing. Then you cannot be held guilty of sedition. So there is one more important point. It is not sedition merely to criticize the government, however bitterly or forcibly that may be. So even if you forcibly criticize the government or the government measures, you bitterly criticize the government measures or government, like the opposition parties do. For example, you are shouting slogans, etc., against the government or government measures, or you are shouting slogans to overthrow the government by voting against it in the next elections. You are exciting people to not to vote against the present government, to vote against it in the next elections. Do you think this is sedition? No, this is no sedition, and this is the genuine rights of the people of India. They can do all these things, but the thing is that there should not be element of any violence. There should not be any element of exciting of the people against the established government of India. And though they have the right of Article 19, freedom of speech and expression, freedom to assemble, the thing is that a balance should be there. There should be balance between Article 19 and Section 124A of IPC. There's a little minor difference where your sloganing becomes violent and where it doesn't become a violent area. The thing is very minute. It's very difficult to take out the main crux of sedition in these type of circumstances. So it's the job of the investigating agency to see whether the elements of sedition are there in that particular meeting or not. So as far as sedition is concerned, I am telling you each and every important point. Then there is a case of Kedarnath versus State of Bihar 1962. In this case also the constitutionality of sedition law, that is section 124A of IPC, was challenged in the Supreme Court as it is violative of Article 19(1)(a), freedom of speech and expression. But Supreme Court said that no, it's totally valid and not violative of Article 19(1)(a). But court gave precedence to the freedom of speech and expression. Court gave importance to freedom of speech and expression. However, if anyone uses his freedom of speech and expression, that is Article 19, to incite people to do or commit violence, this is very important, then he or she can be booked under sedition under section 124A of IPC. So if he incites people to commit violence, then obviously he can be booked under sedition. Because if you are inciting people to commit violence, then you are also violating public order. And since public order is also one of the reasonable restrictions under section 19 clause 2 on which freedom of speech and expression can be curtailed or restricted. So law on sedition is constitutionally valid. Then there is another case of Balwant Singh versus Union of India 1995. In this case, Supreme Court said mere slogans, shouting of slogans, no matter how unpalatable, that is unpleasant or difficult for the mind to accept. Here, where for whom it is difficult to accept, the government of India. So if you are shouting the slogans, they are unpalatable, they are very unpleasant to hear, they are very difficult for the government to accept. They won't be deemed as sedition because everyone has the freedom of right, freedom of speech and expression under Article 19. But this is very important. But if you are inciting the people of India to commit violence, for example, you are calling people to raise arms and collect arms to overthrow the government of India, then you can be booked under sedition under Section 124 A IPC. Then there is one more case of Sharia Singhal versus Union of India 2015. This is the latest case, I must say. And there may be one or two more cases which are more latest than this case, but this is the landmark case. Shreya Singhal versus Union of India 2015. This is a landmark case for all those judiciary aspirants. So this case is very important. In this, Supreme Court defined what free speech actually means. Supreme Court said that through your words, you can advocate whatever you want to advocate. You can propagate whatever you want to propagate, but you don't excite people to violence. That means advocating any idea is your freedom of speech and expression. Propagating any idea is your freedom of speech and expression. But you can't incite people to violence. You can't incite the people to commit violence. So if because of your speech there is breakdown of public order, you are disturbing the peace and tranquility of the state, you can be booked under sedition under Section 124A of IPC. So law is clear, Supreme Court rulings are clear. How unpleasant the words are, the government may not like those words. They seem to be unpleasant to hear. As far as the government is concerned, the government doesn't like those words. There is no sedition. But inciting the people to commit violence through those words is definitely sedition. Recently, Supreme Court Chief Justice N.V. Ramanna asked the central government whether we still require this sedition, as I've already told you. So, Chief Justice asked the central government whether we still require this sedition law, Section 124A IPC, after 75 years of independence. So, it sought a reply from the central government, and Attorney General and Solicitor General said that this law, that is Section 124 AIPC sedition law, should not go completely from the statute book, that is IPC, but Supreme Court can prescribe some parameters in which cases it can be applied and in which cases it can't be applied. So this was basically about sedition. I hope you like this lecture. In the next lecture we will be dealing with some other important case. So do subscribe this channel and share the videos as far as you can. Thank you very much. Best of luck.